All right.
Please be seated.
Okay, welcome everyone to the 2022 Charles S. Desmond Statistical Competition. My name is Carolyn Duttweiler. I'm the president of the Buffalo Newport Board. Now the time for this round. This year's competitors will be arguing the case of Klein versus Oregon Bureau of Labor Industries. On behalf of the Buffalo Newport Board, I'd like to thank the judges for volunteering their time to make this competition possible. Shortly, we will begin the round with arguments from the petitioner and conclude with arguments from the respondent. The petitioners are Dean Company 1, Tiffany Rowe, and Miriam Trinanovich. The respondents are the same brief, Matt Yamamoto, and Matt Hitch. The judges for this round are Ian Viva Evanovsky, as well as Linda Finley, and Sean Eldridge. Judges are encouraged to offer comments and suggestions to the competitors. In the round, however, scores will not be offered at this time. Judges should be aware that the team numbers are random and do not reflect rank in this competition. We will now begin on the round. Oyez, oyez, the United States Supreme Court is now in session. Presiding are the Honorable Justices, Chief Justice Eldridge, Justice Abramowski, and Justice Finley, hearing the case of Klein versus Oregon Bureau of Labor Industries.
All right, good afternoon, everyone. We'll hear first from the petitioners. Ms. Trinanovich, did I say that right?
Correct.
Go ahead.
Mr. Chief Justice, and may it please the court. I would like to request 2 minutes of rebuttal from the court, 1 minute for myself and 1 minute from co-counsel.
Very well, thank you.
Thank you, Your Honor. As stated, my name is Miriam Tranovich. I am here representing petitioners and clients with co-counsel, and we are here today to argue for the application of strict scrutiny to their claims. We are arguing the court should return to its pre-Smith jurisprudence and apply a strict scrutiny analysis to the free exercise claims that the clients are presenting in the face of a generally applicable neutral statute.
Well, even if we do agree with you and apply strict scrutiny, well, why would you win on this strict scrutiny? I mean, what would be a less restrictive way for the government to achieve what I assume you will concede is a compelling interest in preventing the indignities of discrimination?
Yes, Your Honor. Under strict scrutiny, we would still prevail here. That is because the Oregon statute in question requires the non-discrimination against certain protected classes. These certain protected classes are defined protection underneath the amendments of the United States, namely the 14th Amendment equal protection. Here, the statute in question, although generally applicable, when it's applied to the clients in the expression of their beliefs, and
You're not answering my question. I'm very familiar with the statute. I'm very familiar with the strict scrutiny standard. The strict scrutiny standard requires a compelling governmental interest, which I believe you nodded yes when I said that you can see that that is satisfied here. And then it requires that the statute in question be the least restrictive way of advancing that compelling governmental interest. So my question to you is, under this, if we adopted strict scrutiny for the free exercise, what would be a less restrictive way, less restrictive of any imposition on the free exercise of religion for the government to achieve its compelling interest in preventing the indignities and harms of discrimination?
yes, Your Honor, we could look at a different form of a statute. We see the religious exemption statute that was applied in Hobby Lobby. That was a statute that was found to permit a religious exemption when applied to a privately held corporation. Such a statute would recognize the religious beliefs that are protected under the First Amendment of the petitioner's defines. Such a statute could easily be applied to another business model, such as defines a couple who are in furtherance of their religious beliefs.
So I take it your answer then is the less restrictive way of achieving the governmental interest is to let anybody who has a religious objection to complying with the statute to be allowed to not comply? So in other words, basically to have a religious exemption from the general statute preventing discrimination.
The generally applicable statute itself could be changed, I agree with you, to allow an exemption for religious view. In particular, if
Then
that,
what's left of public accommodation clause? I mean, there are religions who do not believe in the mixing of the races or the mixing of people of different faiths. There are religions who believe in human sacrifice. I mean, so what happens to, doesn't, I mean, this is exactly what this court in the majority opinion of Smith cautioned about, is that if you allow basically an exemption from following general laws to anyone who said that would impinge on my religion, you basically have everybody being able to say there's some new religion that now they don't have to follow the law. I mean, I will join the Church of No Taxes tomorrow if we reverse that.
correct, Your Honor, this court has addressed that question, actually. If we look at the Bolton case, for example, there was an institution, a foster care institution that subscribed to certain religious beliefs of the Catholic Church. That institution was allowed to, for example, if we are looking to draw a line somewhere, express its beliefs through its business model. And those expression of its beliefs were a free exercise claim and also free expression.
In your understanding of free exercise, is there a distinction between the religious core tenant or anything else that's incidental collateral? Or a strict should be equally applicable subjectively from the perspective of the religious practitioner?
So from the religious practitioner, that the court should be objective when looking at religious beliefs. We know that court here does not evaluate the strength of someone's belief, and we'll not get into that question. However, when there is a free exercise claim asserted, as in the client's case here, and if we look at another part of Smith, which could help us answer this question, is the hybrid case doctrine. For example, you have a free exercise claim that is alleged in conjunction with another fundamental right, and in the client's case, that's free expression.
Well, I want to talk about the hybrid claim in a minute, but how does the Oregon law actually burden the exercise of religion? Because I don't see it. The law's not prohibiting them from engaging in any practice. So how is it?
So we can look at, Your Honor, a few cases where we have found a generally applicable statute applied to individuals who have sincerely held religious beliefs. And we have found that the court does decide in their favor. For example, if we look to the Sherbert test, the Sherbert case, where there was a burden that was found to be more than just incidental.
But in Sherbert, I mean, this is my place, because in Sherbert was basically saying, to someone whose religion said you should not work on the Sabbath, Sherbert said, well, if you work on the Sabbath, you get fired and you don't get unemployment insurance. That was an impingement on an actual practice that the religion commanded that you do. Just like in Smith, their religion said you must take peyote during the ceremony. Does the client's religion say you must bake cakes?
Your Honor, I understand the example that you are drawing from Smith. And here, if you look at this client's business, the record shows the clients conduct their business in a way that is in the pursuit of their belief that it should be done in the furtherance of their subscription to their religious belief and in furtherance of their devotion to God.
Well, I understand that, but they're not being asked to convey any type of a message. They're not being asked to do something that would require them to exercise certain rights. They're just being asked as business to provide a service. And the service that doesn't, have any kind of connotation with it. So that's where I'm hung up.
Your Honor, you are correct. They are being asked to provide a service. However, I would disagree and say that their service does provide a message. The clients have testified that their cakes that they create are not only artistic expressions, but they're artistic expressions that are in furtherance of their religious beliefs.
Right, but do we look at their how they view the speech, or do we look at that objectively? right? Because I can think of a lot of situations where you might have a message that means something to one person and something to somebody else. I'm having a hard time drawing the line, right? I look at what your clients do as producing a cake. The cake doesn't have, a rainbow flag on it or something that says, I support X. It's a cake.
Your Honor, it is a cake, but it's much more than a cake to the clients. So there is a subjective element where the clients do believe what they are creating is art and they do believe what they are creating is expression.
So let me just clarify, in your understanding then, not only should strict scrutiny be applied in the free exercise of religion, in established and evaluated public accommodation law, but the standard for which you want the court to apply it is the subjective belief in the limitation of their own faith in the exercise of that public accommodation. It depends on what the people think they should or shouldn't be doing.
Your Honor, I would say it is the fact that the petitioners have a religious belief. I don't think the court would go into deciding.
That is not the practice of their religion, and it's not prohibiting the practice of their religion per se.
Nor is it prohibiting the expression of their belief. I did their website yesterday, and their website says, we support marriage as a union between one man and one woman.
Your Honors, if we look at the expression of their religion in conjunction as a lens with also their expression of speech through their cakes, we understand that what they are doing and expressing is not merely a product and that there is a fundamental right at issue here.
I'm just trying to ask, how would you articulate it in anything other than subjective standard from the standpoint, right, of the religious objector?
The subjective standard that they have a religious belief,
But that they have that belief that as such, whatever it is they want to do or not do is in your own mind what's determinative.
under the First Amendment, Your Honors, there is Congress is not to pass any law that prohibits the expression of their religion. And
But that's now we're right back to the same question. It seems to me that what the client's claim essentially is saying is that my religion does not approve of what these other people are doing. So I don't want to have anything to do with what these other people are doing. And how is that an exercise of their religion? And if that is an exercise of their religion, then why wouldn't we now have any person coming up with some religious reason for not having to comply with just about any general law they didn't like?
sure, so looking at the general law in question here, it does not allow any sort of discrimination based on sex orientation, anything like that. Here, because the clients own cake business, they fall under the purview of that law. So they must comply with the law. However, the law would require them to not discriminate on the basis of sexual orientation. Here, the clients are arguing that by creating a cake, they're participating in that certain marriage, that homosexual
Would they
marriage.
sell them a generic? Because I know this bakery doesn't make generic off-the-shelf cakes, but if they did, or would this perhaps be, the accommodation here that they, instead of custom-made cake, they could do, their standard vanilla sheet cake recipe, just put some white buttercream on it and a generic rose or two. Would they sell them that cake?
So that cake would not necessarily be the same type of expression that is a participation.
Okay, but the free speech claim here depends on whether we categorize the cake as expression. Why for the free exercise claim would it matter whether the cake is beautiful, ugly, artistic, unartistic, white roses, black roses, flags, peacocks? If they think the cake is an inevitable symbol of celebrating marriage, wouldn't that mean they wouldn't sell them anything, even if they wanted chocolate chip cookies for their reception table?
Yes, the actual statute here would require a participation. If this was something made not specific for the complainants and the clients here were not forced to, under this law, express the religion and conduct themselves and compel and act against their religion through the creation of any product. If that was not the case, then there would be no strict scrutiny because it would not be compelling an act of religion.
Kelsey, can you help me understand what the limiting principle of your argument is? Because I'm not getting it. especially when you're talking about, we're going to look at the subjective viewpoint or intent of your client, right? Because to me, that says, as long as they believe it, no matter what it is, they get an exemption. So if you don't like people of a particular race, just say it. If you believe it, you're exempt. Or religion, all sorts of other invidious matters of discrimination. So if that's what we're looking at, I mean, what's left of the Oregon law?
So the Oregon law just protects against discrimination. The Oregon law is also in furtherance of constitutional amendments and this first jurisprudence protecting other classes, namely under the Equal Protection Amendment. That protection does exist for other classes.
But I think you're asking us to basically adopt a holding that says the Oregon law and any other state's public accommodations law protects people against discrimination except for discrimination by people who say they have a religious reason for doing so, which to me would apply as much to the caterer as to the party who rents the reception hall. I own this venue. I do not believe that Black people and white people should marry each other, and that is my interpretation of the Bible. Therefore, I will not rent my reception hall to you because you're white and your intended spouse is Black. Would you concede that under your position that would be no longer able to be sanctioned as a violation of the policy of immigration?
That would be sanctionable, Your Honor.
It would be. Then why is that case then different from the ones?
Although my time's up. Thank you, sir. In this case here, the clients would be unequally subjected to certain compelled conduct under the Oregon law. The Oregon law does protect against discrimination against certain classes. However, the Oregon law has the unequal and burdensome effect on the
You
client.
haven't answered my question. What is different in the client saying, we don't want to bake a cake for gay weddings because our religion doesn't approve gay weddings? For the person who owns a banquet hall saying, my religion doesn't approve of Black people and white people intermixing, and I will not rent my banquet hall to anyone who wants to use it to celebrate their interracial marriage.
Yes,
Clarence and Ginny Thomas, stay away from me. Or Ketanji Brown Jackson and Patrick Jackson, stay away from me.
yes, Your Honors. The court here can, if strict scrutiny is not obviously applicable to the client's case, the hybrid case doctrine does offer us the means to get there.
You won't concede. Will you? So you're not conceding that my religious-based objection to interracial marriage, refusal to rent your banquet hall, is actually the same as the client's refusal to bake a cake based on their religion?
If the banquet hall owners in your hypothetical question see themselves as participating in that celebration somehow in the same way that the clients
Do
find.
you think renting a banquet hall to the people so they can hold their actual wedding reception in it is participating in the wedding reception? Seems a little more participatory than putting a cake on the table to me.
Yes, Your
No
Honor.
venue, no party. I've been to plenty of nice wedding parties that don't have cake, but I've never been to a wedding that didn't have a venue. I'm sorry, we've let you go past your time. We should let you sum up.
Your Honors, I do recognize the concerns we have with the seemingly limitless opportunity overturning the general applicable statutes would create. However, if we look at the burdensome effect of this statute upon the clients and realize the rights that they're asserting are protected under the First Amendment, the court can find under strict scrutiny standard or by applying the hybrid case doctrine by finding that there is compelled expression of beliefs against their faith and First Amendment expressions as well, that this statute should be analyzed under strict scrutiny and should be overturned.
Thank you, Mr.
Your Honors.
Scrub.
Good afternoon, Your Honors, Mr. Chief Justice, and may it please the court. My name is Kristen Crowe, counsel for the petitioners Melissa and Aaron Klein. The core question on appeal is whether Oregon's public accommodations law can be applied to compel the plaintiff's protected expression in violation of their sincerely held beliefs. Your Honors, we would submit that it cannot for three reasons. The first being that the plaintiff's custom wedding case are protected expression under the First Amendment. The second being that the government cannot compel speech when it violates sincerely held religious beliefs. And the third being, because Boley's final order compels speech, it is subject to strict scrutiny, which it cannot withstand.
Why is that? Why isn't this an incidental burden that's covered under O'Brien?
So the fact that it compels the plaintiff's expression. So ordinarily, while a content neutral law that incidentally burdens speech would be subject to intermediate scrutiny under O'Brien, when the law as applied to the particular plaintiff has the effect of compelling speech against their religious beliefs, then it is subject to strict scrutiny, as this court held in Farley. The court held that a public accommodation law.
It seems like that argument wants to focus on all the creativity that goes into making the declarations. Why shouldn't we focus instead on the sale of the cake or the decision whether to provide service to the prior voters? What, I mean, isn't that really what was done here? They said, we refuse to accept you as a client. I.e., we refuse to sell you a product, a cake. And isn't that act squarely under the practice?
No, Your Honor, because here we're dealing with speech. And so here, the fact
Well,
that
I guess that's my question. If what they really refuse to do here is to agree to take them on as a client, to sell them a cake, why are we dealing with speech as opposed to the conduct of selling or conducting your business?
I was gonna ask a similar question for everyone. How is a cake speech? Let's start with
yes, Your Honor. So the kind of cakes are certainly not every cake is inherently expressive. However, the kinds of cakes are expressive because every single cake that the client's designed is a reflection of Miss Klein's aesthetic judgment and artistic talent in carefully sculpting, crafting, and molding the
you're saying in this case, the cake is more like art.
Yes, Your Honor.
What difference would that make? Why would it be, if it was an artistic product, different from any other type of product for sale in the store?
Well, simply the fact that they're being sold for a profit does not mean that they don't have First Amendment protection. As this court stated in Riley, simply the fact that the speech is being sold for a profit, it still receives First Amendment protection. And here, every single cake is a reflection of the client's aesthetic judgment and artistic talent.
Let me ask this with a slightly different mechanism. Okay. I decide I want to open an art gallery, a business of selling art to the public. Now, I will concede that every object for sale in my gallery is art, and is art as art is protected by the First Amendment. Now, under your argument, can I say, it's a matter of First Amendment belief, I really, really, really don't like evangelical Christians. So I will ask everyone who comes into my gallery, what is your religion? And anyone who says I'm an evangelical Christian, I will say, turn around, please, and go out. I will not sell you any of the art in my gallery. I have just expressed my belief. And I have said, I do not want to, my expression of my belief is that I don't think people of your persuasion should own art. At least my art. So
Your Honor,
why is that if we rule in your favor on the free speech clause? Can I not open a gallery that will openly discriminate against whatever sort of customers I want?
No, Your Honor, that's not our position. That would be an objection to the person, not to the message. And further, in that particular instance, the art is already created, and therefore there's no compelled.
Okay, fine. So I'm gonna go home tonight and I'm gonna make one of the paintings that I want to sell. It's a difference whether if your position is if it's art, it's covered by the First Amendment wholly as speech. What difference does it make whether you're selling art that you yourself make or art that's used? It's art is art.
So in your scenario, did you make the art?
And my question is, what difference does that make? If art is speech protected by the First Amendment, what difference does it make whether you're selling art that you made or art that somebody else made?
Well, the case,
If the reason you don't want to sell the art is because of a belief,
I mean, every single cake is the client's expression in this instance. I guess that would be the difference here, is that the client's every single cake was a reflection of their deeply held religious beliefs and also regarding their.
In this case, there was no message on the cake. It wasn't like they're asked to write a slogan or a political message or a religious statement. There was no actual, what we would consider traditional speech, like language, even requested, right?
Yes,
So we're putting that aside, that there was no slogan or identifiable political speech. So you're saying that in this case, it's expressive speech sufficient for free speech protection in this type of circumstance, just by being handcrafted, original.
yes, Your Honor, you're correct. There were no words or symbols. However, words and symbols are not a requirement for speech to be protected under the First Amendment.
but, okay, but let's talk about the Spence Johnson case. Okay. Because O'Brien says if it's pure conduct, it's under the O'Brien test. If it's Spence Johnson say, well, if it's expressive conduct, it's maybe going to get strict scrutiny. So expressive conduct, let's say, is something that the person engaging in the activity intends to convey a message, which, I think you've argued very persuasively that clients certainly intend to convey a message. But what about the second part of the Spence Johnson test? That it will be understood by those who observe it or see it that it is intended to convey a message.
Your Honor, the Spence Johnson test is relevant for evaluating expressive conduct. And in this case, we're dealing with pure speech, and therefore we
Well,
would.
let's assume we decide that it's more like expressive conduct because it involves the creation, as you say, the handcrafting of something for sale. How do you address the second part of the Spence Johnson test?
So under the Spence Johnson test, the first part would be whether a particularized message was conveyed. And under the second part, whether a third party would be able to.
Right, and that's exactly what
Yes.
I asked you. Why? I mean, I assume you've been to some weddings. Have you ever gone into a wedding hall and looked at the cake on the table and said, oh, wow, that baker is sending their own individual message about what they think of these married people getting married? Have you ever honestly thought that the baker of the cake was trying to convey their own message?
Well, in this instance,
Assuming we know.
in this instance, the record does reflect that under the Spence Johnson test, the second part would be satisfied.
Where's that in the record?
Under the record, it states that the client's customers expect that they will receive a cake that precisely reflects, the artistic vision.
I get these points, but Ms. Crowe, here's what I don't understand. It seems that being handcrafted is an important part of the test. Do you understand that?
Yes.
All right, so we have all these things that are handcrafted, right? The suit I'm wearing today. I went to my favorite tailor and told them kind of what I wanted it to look like. And, but I said, you make suits. That's what you do for a living. Give me your best product. It's handcrafted. I don't understand how my suit conveys a message other than it's a suit. Much like a cake that just says, I'm a cake.
Or the wedding dress, you say to the designer you commission the dress from, you decide whether I look better with lace going up to my neck or a deep décolletage. You're the designer. I think anybody's going to look at that dress and say the designer has conveyed a message other than this.
So, Your Honor, in your example regarding the tailor, we would first look to whether the tailor, intended to convey a message. And in that instance, there would be no inherent expression But here we are dealing with cakes that are inherently expressive. And I think that's the difference between the Taylor in this instance and the Klein is that,
Okay, let's assume strict scrutiny was applied. Do you think a review would find it so burdensome to have an expressive, non-symbolic, non-speech written cake to win against public accommodation laws of anti-discrimination? You think it would survive strict scrutiny, and if so, why?
so you mean
If we applied strict scrutiny?
to be required to create a non-expressive cake? So if there was no expression involved, then there would.
No, I'm sorry, let me back up. In this exact circumstance, let's just say we agreed with you and strict scrutiny was the appropriate frame by which to make this judgment. Do you think under a strict scrutiny analysis, right, the nature of this case speech is sufficient, right, for us to find the public accommodation law, right, too burdensome for free speech?
Yes,
First
Your
Amendment.
Yes, Your Honor, because under a strict scrutiny analysis, there must be a compelling state interest that is narrowly tailored. And in this instance, it compels the kind of protected artistic expression, and the law is not.
Would you consider anti-discrimination to be a compelling state interest?
I would concede, Your Honor, that certainly it is an important state interest to.
Important but not compelling. Important sounds like intermediate. Compelling, you think it's compelling?
It could certainly be compelling, but regardless of how compelling it is, it must be narrowly tailored.
Look, so I'll ask, I think I'll ask, Justice Abramowski's question the same, in a slightly different way, as a question I asked your companies. What less restrictive alternatives, here of speech, as opposed to free exercise, could Oregon or any other state do to advance their very, very strong, not compelling interest in preventing discrimination?
Yes, certainly, Your Honor. BOLI could create an exception under the public accommodations law for artists that are in the business of creating expression. So if there is a message that would.
Then we're having endless cases about who's an artist and who's sufficiently crafted. What about the person who designed to make furniture? What about the person who owns a clothing boutique and says, I carefully curate based on my own design eye and aesthetic sensibility every item of clothing in my boutique. And so, and my decision to let anyone wear one of my carefully curated, for my aesthetic fashion sense, items of clothing in my boutique means that I consider that person to be going out in the world and furthering my expression of fashion. So I'm going to be very selective about who I let buy from my boutique. Is that sufficiently, creative, expressive? Is that? And so again, where's the slippery slope you're in? What do we have left for public accommodation?
Your Honor, I think Hurley provides that framework for evaluating the line. And first, we would look to whether if the speaker is intending to express something, and second, if they are trying to express something through whatever medium of expression that it is, whether they're being compelled to express something.
The clients here are concerned that anyone looking at the cake on the cake table at the wedding reception might think that they, clients, are expressing a message about the couple that just got married. Isn't the accommodation or the way out of their dilemma to simply put a sign on the table saying, this cake conveys the message of the married couple, not the baker?
Your Honor, I see my time is up. May I answer?
You certainly may. We're getting lots of questions today. Please do.
I'm sorry, could you just repeat the last?
It seems like what you're trying to say is your clients are very concerned that they believe their cake expresses a message, but they're also very concerned that others seeing that cake at the wedding hall will think it conveys a message that they, the clients, actually personally approve of the marriage between these two people. So rather than ask for this huge, potentially huge exception that can undermine public accommodation, why not just put a sign on the table next to the cake saying this cake does not express any message by the baker?
So actually,
Which most people at the wedding will look at that sign and go, duh.
as this court established in Hurley, a fundamental principle is that the speaker has the autonomy to choose the content of his or her own message, and thus forcing the speaker to put some kind of disclaimer would not be compatible with the First Amendment principle that the speaker does have the autonomy to choose the content of his or her own message.
Well, but it's, you know, it's really the court was saying. It was the South Boston Council's parade. It was their parade. By forcing them to let someone march in their parade who conveyed a message different from their parade's message, they were actually changing the parade's message. Is that really what the clients are saying?
Like, there's no secret when Bills win the Super Bowl that we're not gonna let Patriots fans march in, right?
Right.
I mean, everybody understands that that's not just kind of like, everyone's gonna show up at the block, or we're gonna tell you what you have to
Doesn't
do.
matter how much Tom Brady wants to march in the parade. We don't want him in our parade. It's our parade. We control the message of our parade.
I'd like to state for the record that I welcome Tom Brady for any.
We can march one there.
All right, did you know? So yeah, so how, I guess that's how I see the difference for here. Here, it's the prior Bowman's wedding, not the Klein's wedding. I could see saying to the Kleins, no, you do not have to let it cake. If you think it's ugly or, you know, said that God is horrible, be in your wedding. But this is the prior Bowman's wedding. So if the cake is a message, whose message is it really?
Your Honor, it is
Wedding
both.
couples or the babies?
Your Honor, it is both the couple and the artist. The artist speaks through the cake, and so every single cake may be a reflection of the couple, but it's also a reflection of the artist herself. And so, you know, as this court established in Hurley, a speaker's message does not have to be isolated in order to receive First Amendment protection. So
What about the second? I mean, again, 'cause I'm really interested in testing limits or whether there are any limits at the free speech argument here. Okay, so I think everyone will concede, and many courts have said that photography is an art form that is a form of speech or video. So, so now we have a photographer who sells it, will take people's pictures and, you know, sell them to people. Portrait artist. But again, that portrait artist has, you know, suppose they're white supremacists, and they just don't think that Black people should be dignified by portraits. So they will allow white people to avail themselves of their photography portrait service, but they will not let any Black customers avail themselves of their photography portrait service, saying it's photography, it's art. Everything we do is viewed with our aesthetic judgment, and our photographs convey an artistic message. Is that now going to be okay under your interpretation of free speech combined with public accommodation law?
no, Your Honor, because that would be an objection to the person. And here we're dealing with an objection to the message. So that would not be permissible.
I don't understand that. See, they objected to the two people involved here getting married. Why is that an objection? So if Rachel had come in and said, I'm marrying Bob, it would have been fine, right? Assuming Bob was married.
Yes, but in this case, we're dealing with the client's religious beliefs where they don't subscribe to a particular kind of marriage.
But your free speech, see, but now you're conflating the free speech and free exercise. That's why I'm very worried that the free speech claim, if we allow it, completely obliterates the accommodation law, because it doesn't require a religious basis for not wanting to provide handcrafted, artistically beautiful, expressive things to people anymore. It could simply be, my belief is, I don't like your kind. My belief is, I don't want people like you owning my beautiful creative things or being the beneficiary of my creative aesthetic judgment. So where, once we say it doesn't have to be a religious objection anymore, but it just is simply some belief you have about the meaning of your creative object, where does it stop?
Your Honor, there are certain state interests that are so compelling, such as eliminating racial bias and protecting certain classes of
Why isn't eliminating sexual orientation bias equal?
Your Honor, it is certainly an important state interest, but this court addressed this issue directly in Burley and in Dale, where this court held in Burley that a public accommodation law could not compel a parade organizer to include an LGBT unit. And similarly in Dale, this court also held that a public accommodation law could not compel the Boy Scouts to include a gay rights activist when it went against their First Amendment right to oppose.
So certainly under the First Amendment, the clients would be free to not invite gay people to their wedding. But that's not what's going on here.
Council, we've kept you way over your time, so why don't you take 20 seconds and wrap up for us and,
Yes, Your Honor. Thank
move
you.
along. Thanks, Mr. Trump.
So Oregon's public accommodation statute, as applied to the client, violates the fundamental rule of protection under the First Amendment, which is that a speaker has the autonomy to choose the content of his or her own message. And as the record demonstrates, the client's wedding cake are an expression and they constitute protected speech under the First Amendment. And thus the client cannot be compelled against their religious beliefs to create such expression. And as such, we respectfully ask that the judgment of the Oregon Court of Appeals be reversed.
Thank you, Council.
Thank you.
Don't worry, Mr. Mitchell and Mr. Gamble, I'm sure we'll have just as many questions to keep you guys going too. So with that, we'll hear from the respondents, Mr. Mitchell.
Good afternoon. Judge Justices, please court. I am Matthew Mitchell. I'm representing the Oregon Bureau of Labor and Industry. I will be responding to the petitioner's claims on free exercise clause. My co-counsel, Matthew Milano, will be discussing the free speech clause. And it needs to be stated at the outset that we are asking for affirmation of the judgments below because the petitioners clearly committed status-based discrimination in violation of the public accommodation statute. And we urge the court not to allow free exercise defenses of clearly prejudicial actions and uphold public accommodations.
Is there a distinction in kind between an action that is for religious practice and something which is ancillary to the practice of the religion? Purposes of determining the court's scrutiny.
The courts have been very loath to assess what is central from the internal perspective of any religious community, because that opens up the door, which is what the petitioners are asking for. So if they can open forward to consent, we open up the door into making administrative bodies and courts adjudicating religious sincerity, religious conviction, and religious
Understand. I do not hear the petitioners as saying, you know, that there are rules of not having to assess sincerity. I mean, I think our law is so well established. We don't assess sincerity. I think what I hear petitioners saying, and why is this an exercise of religion, the burden on religion is that it's no different than Hobby Lobby or Fulton, where the successful petitioners in those cases were saying, requiring us to have any even slight participation in enabling other people to do something that violates our religion is a substantial burden on our religion. So why don't Hobby Lobby and Fulton directly control the question of this is in fact a legitimate exercise?
I think that
Leaving aside the next question, within the standard scrutiny, just on the exercise of religion, how do you distinguish the crime claim here from the sort of complicity claims that the court recognizes substantial burdens in Hobby Lobby and Fulton?
I think first, Justice, one of those cases would be distinguished because we're dealing with public facing services and public accommodations here open to the general public. And in Hobby Lobby, you're dealing with the employer-employee relationship and the internal governance of the company. So that is quite different.
But it was still a generally applicable law and regulation that, any employer provided health insurance should provide, cost coverage for companies.
Yeah, I'm not sure that that's quite right when you're asking us to do, if free exercise of religion is triggered, then it doesn't matter, the nature of the law in question. It either is a question of whether or not we should be applying strict scrutiny or a lesser standard, right? So what is the difference in kind? If it is appropriate for the court to have no capacity to distinguish between the nature of form of religious practice or the importance of the subjective standard of the petitioner's belief, we have no right or capacity to make that judgment, then why isn't strict scrutiny inherently in the appropriate frame?
Well,
It may not, though, we may determine that the law was sufficiently narrowly tailored, right? And that there was a compelling state interest. But I'm unclear as to why strict scrutiny couldn't simply be the applicable standard at all times.
Now there's, I think, a few different questions embedded in that.
Of course there is.
I-
That's why we're finding
Yeah,
it.
well, I'm curious, so if I can unpack them a little bit. So I think one of our position would be that we would survive the heightened scrutiny anyway, because it is a compelling state interest. But
But
there's
that's
no
only
need,
part of strict scrutiny. That's like step one. What
That is
about, what
and is
about,
it narrowly tailored to, and yes, it is, this is,
why? Why is it past the narrowly tailored and least restrictive?
this is only concerned with services offered to the public and not allowing people to be denied those services based on personal characteristics, race, religion, sexual orientation, color, national origin. That is, I think that would pass muster. I don't think we need to get there because I think one of the purposes of sin is just as referenced earlier in the Sharia majority was the concern around what it would mean to allow exemptions to generally applicable laws based on religious statements of preference. That there was a concern about that being either, I think, not to say people would be using it in bad faith, but to say that it would open up all sorts of claims that the courts and administrative bodies don't actually deal with. It doesn't mean that the courts don't play a role in assessing, to some extent, the sincerity of certain cases.
If you agree that we are ill-equipped to determine these types of cases, then doesn't that actually mean strict scrutiny is the more appropriate answer? And that there's a legitimacy in the argument that subjective standards would be appropriate.
I think, at least as it currently stands under Smith, one of the other tests is whether the burden is an incidental one. And I think that the courts can adjudicate that a little bit more carefully and have been. So,
But determining the burden is incidental doesn't it also require us to make a judgment about the religious importance of the act? Or prohibition?
well, I think it requires less judgment than would be the case if Smith were to be overturned. I think that, and I think that if you go back to Sherbert examples of that in some sense, telling the Seventh Day Adventist the seventh day isn't that important. I don't think you need a lot of discussion to say that is a central component. But I think
If you're not giving me an explanation, if we're not supposed to determine what is or isn't a central component, if we're supposed to avoid those sorts of just judgments at the outset, by what metric would we be able to make these decisions?
well, I think the metric, at least currently, or if you would.
Tackle.
Okay, well, currently, the test is the effects test, right? Incident, and this, one of the issues with allowing religious exemptions to the generally applicable law is that once you begin to allow, already under Smith, once you allow an exemption, you're triggering more higher scrutiny, or triggering state scrutiny. But exemptions existing shows the laws are generally applicable. That was the decision in Hialeah and other cases. And in the case of Fulton, in fact, is that allowing the exemption was part of what and carving out exemptions becomes a problem. And if you go through the concurrence in Fulton, not the Alito concurrence, but the Kavanaugh and Breyer concurrence, it's not clear to those justices that you would have strict scrutiny across the board, or that it would apply, at least as they wrote, to institutions and individuals equally if they overturn Smith.
Since you brought up the Alito versus Thomas concurrence in Fulton, which writes a very lengthy and compelling argument for overruling Smith, tell me why they're wrong.
Well, simply put, I think our position would be that Smith itself does not overturn these prior cases. It claims to uphold and affirm and incorporate them. Now,
But come on, didn't they do that through this sort of this device of this hybrid rights theory? I mean, come on.
well,
I mean, wasn't it just Scalia didn't want to admit that they were, upending an awful lot of precedent?
well,
So he sort of said, well, but we're not really.
yeah, I hope not.
I mean, so I guess what is your argument then? Is, you're saying, well, Smith didn't actually overrule a lot of precedent because of the hybrid rights remark?
Well, I think that I think the position that has come out why hybrid rights seems confusing is because I think it's a way that the court in its reasoning why it's dicta and why it hasn't been applied universally is because they are looking for a way to get at what is kind of the nexus of religious beliefs and other spheres of life. And true religious conduct always affects other aspects of life. And one of the things that is a longer standing tradition is that the court, going all the way back to, I think, the plural marriage cases in the 19th century, is that the courts do not want to adjudicate beliefs, but only conduct, and that they can regulate conduct. And that's a very much longer standing tradition when it is in public interest.
Why do you say that the hybrid rights section at Smith is dicta? Right, because I mean, as I read Smith, the portion that you're saying is dicta is really what we use to explain why we didn't overrule Yoder. So both of those to me don't jive. Those can't be true at the same time. So why is it that you think the hybrid rights section in Smith is dicta?
It is dicta at the moment. It will not be dicta if this court decided otherwise. It's dicta because the circuit courts, some of them treat it as such, and because they are free to treat it as such.
Well, some of them treat it as not.
Exactly.
Right. So
it can be followed or not.
But I guess the question is, right, if it's dicta, and it's outcome determinative to why we didn't overrule Yoder, that seems to me to be a whole as opposed to dicta. So why am I wrong?
Or at least a clarification of the whole thing that strict scrutiny doesn't apply to neutral laws of general applicability, except when they're hybrid rights like in Yoder.
Well, but I think in Smith and in concurrence, there was no hybrid rights discussion to arrive at the same disposition of the case. So I don't know that the logic of the hybrid rights then was the only way the court arrived at.
Well, given the very confusion we're all having, the circuit courts have about whether the hybrid rights is dicta or was essential to the holding, it's caused a lot of confusion, and that seems to be one of the criteria for ruling cases. So why doesn't the confusion engender major aspects of the Smith decision or substantially revisited?
I think the simplest answer is that would be up to this court, and if it declined to do so, it can
tell us why we shouldn't do that. Yes, of course we know it's self-responsible, but we want you to persuade us whether we shouldn't do that.
Well, I think that the overturning Smith, especially with this case where we're dealing with the issues of public accommodation law, it's designed for discrimination. I think that it would open up more problems than we resolve. There's confusion around the city.
Well, so if we overrule Smith, right, then basically RFRA just controls everybody, and not just the federal government. What's the problem with that? That seems like eminently sensible, especially since right? Congress passes as a direct response to Smith. And the world hasn't ended then, so why is that not a eminently sensible way to kind of get us out of the morass that we created 30 years ago?
It doesn't apply to, it wouldn't apply in this instance because that it doesn't apply to the states.
Well,
So, but that's,
if we get rid of Smith, it will.
and would be a new, I guess it would be a new situation, a new position, but the hybrid rights doctrine does not have to be, I think it's a way of giving people a second crack. And I think even I think the Alito concurrence in Bolton, the concerns it had with hybrid rights is, although it was an argument favorable returns, it still is valid. It's it's harder to quantify and understand.
Let me ask just a question slightly different. Okay, so in Smith, one of the arguments that Scalia, the author of that decision, made why there should not be strict scrutiny of neutral laws of general applicability that impact religion is that if they had strict scrutiny, it could lead to parade of horribles, slippery slope, all kinds of things. You know, now people getting out from under all kinds of laws just because it's religious belief, reference to Jim Crow coming back or something. Okay, but Congress basically said we disagree, Supreme Court, and we can pass RFRA, which reinstated the Sherman test and the Wisconsin versus Yoder test. And yes, we understand, but we in the city of Maryland said, oh no, Congress, you can only do that. You can't do that with states because it's beyond your 14th Amendment power to disagree with us. But all of the parade of horribles that Scalia, opinion, and Smith thought would happen if you use strict scrutiny to evaluate all kinds of religious objections to complying with, you know, whether it's the Affordable Care Act, contraception mandate, or whatever, have not come to pass under RFRA. Seems to be that the reinstating for everything but the states of the strict scrutiny Sherman test. Means that we still have generally applicable laws that 99.9% of people follow, and some people get religious objections and the world hasn't done it. So what's wrong with the Sherman test?
Oh, yeah, that's
in response.
we've been a little, we've been generous on the time. We'll continue to do that.
I think that our position is firstly that if Smith was overturned, this law in particular, this particular case would still pass muster. And one of the issues that we're discussing is something that may not be so much hypothetical in the sense that the Supreme Court, there's a way of countering by still following the narrative that Alito sets out, which is that this is something that is in development and discussions how to navigate between changing societal standards and legislation and traditional values that we find certain changes disruptive. And it seems that removing protections from people based on personal characteristics, which is and allowing a blanket exception, which is what is more or less being asked for, that a religious exemption ought to exist.
Be a blanket objection. Why can't we think of the clients more akin to like conscientious objectives? Why is it that way? I mean, that's what we did in Hollywood, right?
Conscientious objectors, there's a distinction there between objections to militarism in general. If you're talking about someone from the Anabaptist tradition,
It's a concept not used just in
yeah,
military purposes, it's widely used in healthcare purposes. You know, we have federal laws that protect the right of healthcare providers based on their conscience to refuse to participate in abortions, things related to abortions, gender reassignment surgery, in all kinds of medical care. I mean, this idea of allowing religion, in other words, the point is this idea of allowing people that have particular religious reasons for not complying with some general regulation or law is just deeply entrenched in our country. And yeah, it hasn't brought public safety regulation crashing down. It hasn't brought public accommodation law crashing down. So, again, why? Maybe Smith is the anomaly here, and then, you have Sherbert, Yoder, and Riffra. And, if Smith is the real anomaly here, the religious objections just get fashion basis review. Why shouldn't it be overruled? Maybe Congress is a thing or two to teach the Supreme Court occasionally. Maybe they got it right.
Well, I think in Smith, if I'm remembering the case correctly, the preferred remedy, the outcome isn't necessarily what the justices seem to find entirely fair to some of the individuals affected, but the remedy was a legislative one, not a judicial one. I would say the facts of this case do not, however, quite match some of the other scenarios we're talking about. We're not talking about a bakery that produces exclusively Christian evangelical wedding cakes. We're talking about a bakery that produces cakes.
Can I ask a question? Let's switch it maybe to, and again, I'm no expert on religion, to a certain extent, possibly the answer to the Supreme Court is not the right venue, but let's make it an Amish store, strict one, which or something where no use of or a different religion that says no use of electricity, either all the time or part of the time or for whatever reasons. And then we have some kind of ordinance that says that those stores must have some electronic system in place for a neutral public reason, security or food safety or something like that. In that circumstance, is there no option for those types of cultural religions to object to the imposition of something?
I think that those objections already exist in the scheme. In particular, religious groups are more than incidental burden. I would think more of a if you were a halal or a kosher butcher, you do not. That is your entire business model is modeled upon only selling this kind of item. The clients were more than willing to take money from complainants when the cake was for someone else.
So you're saying that it isn't really an issue of strict scrutiny, right? Of how we're scrutinizing the law. But what I'm hearing from you is the determination of the burden.
Yes, it's effects, and that is the test that ran through IDEA, and like it's really what are the effects and applications. That is how, because adjudicating other elements is not always easy. Once you have only a particular religious group being exempted or targeted by a law, it's suddenly you're in a very different space.
Right, but couldn't we do that under any levels?
It's not required that it be strict scrutiny. It could be intermediate scrutiny. And again, that's I think the Kavanaugh and Breyer concurrence is not entirely is waffling into whether the justices felt that strict scrutiny would automatically be triggered as soon as it returned. The court wasn't entirely sure about that at the time last year.
Thank you.
Thanks, Mr. Mitchell.
Thank you.
If you want to wrap up, you can, or if you're good.
I've taken so much time, but I would like to say that the Oregon statute protects persons based upon their personal qualities, and we ask the court to affirm the judge's decision. Thank you, Councilman.
Mr. Biondo.
Good afternoon, Chief Justice Eldridge, justices, you may please the court. My name is Matthew Biondolillo, and I am arguing on behalf of Boley, the respondents in the case before you this afternoon. The First Amendment does not protect against a limitless variety of conduct that is intended to express an idea. Where we have a compelling interest that would justify some sort of regulation on someone's conduct that causes an incidental infringement on speech that's attached to that conduct, then that incidental conduct must be tolerated according to our case law before us here. And we believe that is the case here. We do not have a colorable claim to a free expression, or free speech.
Why is using your artistic imagination and your artistic ability to sketch out an elaborate design and then use your aesthetic ability to paint with fondant to bring that creative sketch into life? How is that different from being a sculptor? Painter? Why is that just conduct? I mean, and if it's conduct, then why isn't the sculptor taking chisel to stone? Just conduct.
Well, Your Honor, I understand, yes, sculpture as an art form is something that is imbued with elements of communication that bring forth a message. What we would contend here is we may not even need to get to that step. The denial of services from the clients here fell well before we even got to any elements of a message that could have been communicated. As it's been discussed already.
So you're saying the time at which, the step in the process at which they refuse service is determinative of whether what they were asked to provide was artistic expression or not? That doesn't make sense.
I think, Your Honor, there are potentially two sort of limits here. One of which would be potentially the time. As I was saying, the client's full service is providing custom cakes, right? It's on the record. They've admitted to that here. So that is the accommodation that needs to be provided to everybody. If that's what they're going to do as their business here under, our Constitution, we have ourselves a compelling interest in guaranteeing free access to that accommodation to everybody. A part of that model is the consultation. There's a one-on-one meeting or two-on-one meeting, however many it is, to decide upon that design of what the message would be. That didn't even occur here. And that is a bare denial of a service, let alone an expression.
I think everybody agrees that if it had gone a few more steps further, there would have been creative design. There would have been sculpting with fondant.
I agree.
So, hence I think you're kind of ducking my questions. Why shouldn't the sculptor in fondant, who uses fondant as their sculpture medium, get the same protection by the First Amendment for their sculpture art as the sculptor who sculpts in clay or metal or bronze or marble?
Well, Your Honor, they very well may be guaranteed that very same level of protection if it expresses their message. We would contend here the custom designed case are not, at least in this instance, they would not have been the expression of the clients. They would have been the expression of the prior owners.
What about someone, who offers portraits to people, commission portraits? Someone comes in and says to the portrait artist, I want you to make me look 30 pounds slimmer, eliminate my receding hairline. I want, you to dress me in finery, and I want to look exactly like this. And I won't pay you unless your portrait winds up looking exactly like I want it to be. Does that make the artist's portrait any less protected art?
I think in our current case law, Your Honor, a painting would be considered something that is sufficiently expressive to be pure speech.
Let me just ask you, let me just try to ask this again, because religion and art are two issues that this court has wrestled with figuring out definitions, right? And this seems to be the heart of the matter here of what is expressive conduct. How do we know something is an art? How do we know if it's expressive conduct or just conduct? What guideposts can you give us to try to articulate a standard?
So the standard, Your Honor, that you would apply to decide upon if something is expressive comes from the Spence Johnson line of cases, wherein it's already been discussed. You look at the intent of the artist, the person creating, and then critically the context in which that art is displayed, in which that piece is displayed. So that would be the test. We would contend here, it's clear that the clients, they've stated on record they intend it to be artistic and expression, something that's imbued with their own message. We don't contend that that's an issue. We would contend that the context of the wedding ceremony would be something completely different than the types of cases like in Hurley, where we found that the expression of the person complaining of an infringement is protected.
But why? I mean, early, you're being forced to put a message on your license plate, right? So you have to drive around town, or I'm sorry, Hurley, I'm thinking, well,
Yeah.
Hurley is the Boston Parade case, right? So you can control who's a part of it. I don't understand the context argument you're making, right? Because if I understand it right, I think what you're telling me is that under your view, someone who say a Jewish DJ could be compelled to perform at a Nazi rally, right? Because it's a context. He's just there to be a DJ. Big deal. You're just here to provide a cake. Big deal. Rest doesn't matter. Is that what you're saying?
The element of the context, Your Honor, that is most critical is the degree to which any message that is expressed, which again, we don't know what the message would have been in this case because we didn't get there. But any message that does wind up in that context, the degree to which it's attributable to the artist versus the person putting on, in this case, the rally.
But isn't it always attributable to the artist, right? So in the cake, I mean, maybe you have a stronger argument if the clients made kind of standard cakes and this fell into that bucket. I don't think anybody disputes that the only way they make cakes is if you come in and go through a very specific consultation, right? Much like you would for a lot of service providers. That seems important to me. So why am I mistaken?
I'm sorry, Your Honor, can you rephrase that?
Sure, you were asking about how it is. Now I forgot what you were saying too. The point had to do with the amount of input that the individuals were putting into. And here, as I understand it, the clients don't just bake generic cakes that you can buy off the shelf like at a normal bakery. Right? You have to have that level of very specific input into it to make it more artistic. Right? And that to me seems to be a really important factor. Because I think you were suggesting before, it's just kind of generic, no big deal. So why am I wrong?
Your Honor, I'm not suggesting that the types of cakes that the clients make are generic, they're no big deal. You've seen it on record that they're beautiful cakes. What I'm suggesting is that the message at the end is not necessarily controlled by the clients. If the prior Bowmans had been allowed to go through the design process at the end of it, I would presume they would have been able to decide whether or not to actually display whatever was designed for them. I don't think that they would have shown up at their wedding ceremony or the cake cutting only to be surprised by what the cake looks like and what message is on it. It's our contention that would have been their message. They would have at least had the right to approve it. And for that reason, anything that the clients had put into it would at least be filtered. So at a minimum, or at a maximum, what we'd be looking at might be sort of mixed.
Do you disagree that the cake here is art?
If, Your Honor, if you're going from the perspective of the expression of the person making the cake, I disagree that it's art. I believe it would be the expression of the wedding party. You don't go to the wedding and say,
But so by your logic, then why do the clients charge hundreds and hundreds of dollars for this cake? If it's not important to the clients, and it's only important to the people who gave input, right? Why are they charging so much money for it? That seems to me not determinative, the factor in deciding if this is art.
Excellent question.
well, Your Honor, if you're going to the Master Vincenzo, I believe it is standard, it's at a lower level. We don't necessarily have to follow that. It's just that they charge a lot of money for it. Doesn't necessarily make it art. You can buy all kinds of random things on eBay that are charged a lot of money, but you know the ghost in the jar is not necessarily art either.
But the ghost in the jar also doesn't take any work on part of the people who are creating it. You're the clients, right? And that's kind of my point. That if what I heard you saying before is it's really just the client's art, the clients are telling them what to do. And then the clients essentially are just like a robot, right? Me make cake, don't have to think about anything. And that just strikes me as being incorrect.
And it seems to leave you a slippery slope with any commissioned art no longer has any aspect of the message of the artist.
Isn't that why we call it artisanal bakeries, because they're art like?
Yes, I do believe that they could be considered art light, being, the light part being critical. And I would come back to it still being down to whose message is being conveyed, that would be determinative of whose art it is. And it could very well come down to support very well may decide that there are elements of the client's message imbued within their custom case.
So let's let's just explore this a touch, right? So we've got the working pieces that, the artisan type work can be art. Let's take a different situation like music at political rallies. When you hear a song played at any particular political rally, do the people listening to it believe at some level that the song's artist is supporting that politician? Does it have a meaning? So let's say they're having a political rally at any political party and they're playing music. It's a song. It's a recognizable song.
Trump rallies played Born in the USA all the time. Did anybody think that Bruce Springsteen was endorsing by allowing this song to be played?
I believe the artists believe that, and some of them have then filed injunctions to stop that from happening, certainly. So to some degree, yes, but here I think what you get is a mixture. You get speech and non-speech elements being combined at best, where then you end up going to the O'Brien standard and looking at that. Even if you're to go intermediate scrutiny by which to judge this claim, you have to walk through those elements and see whether or not the infringement on the conduct. Again,
that makes sense.
right,
Or at least right now that's making sense to me as the standard. But whether or not it deserves the heightened scrutiny because it is in fact expressive conduct seems to me to still be an open question in art. Although I'm glad that you reserved the right for the court to use either strict or intermediate scrutiny.
Your Honor.
But that seems to be the question in the context, in the context displayed. If we think there could be messages through works, through music, and we think there could be messages, like you were saying, that are clear through type speech, poetry, one assumes, we're getting back to the idea is it the physical medium of the cake, right? That is the issue, or is it or what's relevant is that it's at a wedding?
Your Honor, the medium is not necessarily the most determined here. And this court has a history of recognizing new and different forms of expression. So what would be determinative here to determine if you get to the expressive conduct standards, since Johnson would be the context. And the Hurley standard, at least in the parade itself, and that was for some other purpose. It wasn't just decided to put on a parade for the celebration of two people.
Well, I'm interested why you haven't made an argument. That's okay, but you know what? I'll ask it on rebuttal. Don't worry.
They get over.
I believe that the Your Honor.
We'll roll for a couple.
I have a question too. We haven't really-
It was brilliant and insightful, and I'm not sure I can remember it right now, but let me,
I'll ask my.
you asked me what we do.
Yeah. So, if we find that the case is either speech because it's art or is expressive conduct under Spence Johnson, will you then concede that under the compelled speech doctrine, that if it's art, speech, or expressive conduct speech, the government cannot force them to make it?
No, Your Honor, we would not concede that. If the court were to find today that that type of conduct does meet the Spence-Johnson standard, we would contend it should be evaluated along the Rumsfeld v. Fair or Turner v. FCC conduit cases line, where the expression is put through another person. Here, it would be a conduit and not necessarily attributable.
But in Rumsfeld v. Fair, we held that it didn't, the law school allowing military recruiters to use their facilities wasn't speech or expressive conduct under the Spence-Johnson test, because we said nobody would ascribe any message of the law schools to the conduct of letting everybody on an equal basis use space. My question is, if we were to find in this case that the Spence-Johnson test is satisfied, and that cakes that clients design and create and imbue with their love of God and celebration of unions between men and women is a form of expressive conduct and thus entitled to First Amendment protection, unlike the conduct of renting rooms from employers that in Rumsfeld we said was not entitled to First Amendment protection, then why don't petitioners win under the compelled speech?
Your Honor, if you were to go down that line and find that there was strict scrutiny that would apply, we still feel that the interests of the government in ensuring equal accommodations is sufficiently compelling, and it was admitted that it is compelling to withstand the incidental burden that we have here on speech. On record, what we have before us that says
It's a compelled speech doctrine saying it's not an incidental burden to make somebody convey a message that they don't want to convey. That's not an incident. We've said in our compelled speech cases that is just as deep a punishment to free speech interests as punishing somebody for saying what they want. Forcing them to say what they don't want is just as bad.
Like in Janus,
Yeah.
right? In Janus, you may get 98% of the benefits of your union, but there's this 2% that you don't like. We can't force you to contribute because of that, if that's how you feel. That's what we said in Janus. So I don't know why that wouldn't be the same outcome here if we find that it's artistic speech or expressive conduct.
Your Honor, I still think if you were to find that there was expression in the conduct, it would still go back to the conduct cases. The expression itself, who is it attributed to? At the end of the day, it is the crier Bowmans who get to decide what's happening at their wedding. So floral arrangements, the band, the music, people will go to the wedding and they will say, oh, who did your cake? They won't say, whose cake is this? And I think that that's a very different type of situation. And I don't think that this court even necessarily need to get to that step. I want to go back to what I said initially. The real issue that we feel is that it exists. The only service that's offered is the custom case of the client that's on the record. And that involves an initial consultation to design something. And even that small amount, that one-on-one conversation, that's conduct that was denied. And under the public accommodation law, that should not be allowed and is quite incidental. Any burden on their speech that could have come from a conversation with those two clients, that would be quite incidental, and I think ought to be something to be allowed for the equal access of all kinds of accommodation.
So what I'm hearing you saying is this rule would basically, if you don't want to make a cake for people you don't like, don't open a bakery.
Your Honor, incorrect. Don't open a bakery that only offers custom cakes designed for specific people. It's a little bit different from Masterpiece. If we're going to talk about a bakery, In Masterpiece, you did have the baker who offered to just,
I don't think it's different on the free exercise. I don't see if the cake is the message of the cake, if the cake affects their religion because they see it as having a featured role in celebrating the union of these people, I don't see what difference it makes whether the cake is generic or fancy. Because the cake is no less a celebration of the union if it's fancy or generic. So on the free exercise, I think it doesn't seem to matter whether it's generic or a fancy. It may matter in the speech.
and then,
So hence the question still, is your position then, does the both parts of the First Amendment that essentially public accommodation laws mean that if you do not, for any reason, want to equally serve all members of the public, then don't.
if you're going to that extreme, which again.
Why is that extreme? Isn't that basically what public accommodation laws are saying?
I would say, yes, that I think the government interest at hand to ensure equal protection, to ensure individual dignity is something that would be compelling enough to withstand that. If you're doing business, then yes. You must have, you have make a final.
Please, yes, we can wrap up, that'd be great.
Sure. So as I've said before, instead of it being a refusal, expressing what I believe we have here is a refusal to engage in fair conduct based upon an indelible trait of the prior Bowman. And I think here the court should find the decision of Foley and the courts below were just in alignment with the compelling interests of the government. And for that reason, I believe we should affirm those judgments today. Thank you.
Thank you, Mr. Villanova. Mr. Tranovic or Ms. Crowe? Mr. Tranovic, very good.
Thank you, Corrigan. I would like to respond to a few comments made by opposing counsel. First, that the opposing counsel suggested that the client's business is different from, for example, a kosher butcher shop, and the fact that a kosher butcher shop is inherently and completely in furtherance of that Jewish religious belief. Here, the clients are similar rather than dissimilar. The entire purpose of their business, which they've stated in the record, is to live their lives in pursuit and
I think you're missing the point of the halal analogy, which is under their religion, you have to treat your animals in a certain way. I don't think there's the concept that there's anything in their religion that says you have to do anything at all with pigs.
I think the analogy, Your Honor, could be drawn in the fact that it's a business and that there's a religious belief in furtherance of that business, that there are these two existing facts in the same element.
And I want to ask you the question we ended. So what's wrong with the public accommodation law basically meaning that if you, for whatever reason, cannot provide your services to all members of the public equally, choose another line of business?
Sure, Your Honor. If we were to apply strict scrutiny to this, we find that that law is not narrowly tailored enough. And there is no exception provided to provide for the expression of your First Amendment rights, such as your freedom of expression and then freedom of exercise of your religion there.
But I guess that's the question is the public, right back to where we were talking before. The public accommodation laws have to allow exceptions for expressions of beliefs or religion, then again, all
There may be exceptions, Your Honor, but under strict scrutiny, you would find that those exceptions are appropriate here and afford the same types of protections to people who need protection under the public accommodation law, and those people applying the accommodation in themselves. The fact that the clients choose to operate a bakery should not contradict their First Amendment rights that are first provided for them in the Constitution.
So speaking of the Constitution at first provided, thank you. We'll keep you for elements too. Would you agree that under our cases, especially as of late, that we have to look to the historical understanding of the constitutional right at the time of the founding or here at the time of the First Amendment's ratification?
To answer that question, Your Honor, I would actually refer to Justice Finley's comment earlier made to opposing counsel, suggesting that Smith is actually an anomaly. And if you look at the historical precedent leading up to Smith, we find that the court has applied strict scrutiny to generally applicable statutes.
That was the question is, don't we have to look at what the understandings were and the laws were like in 1780?
Right, because if you're right about what you just said, I think Dobbs and Bruin come out the opposite way.
Yeah.
Right, so I think in Dobbs and Bruin, we basically said, we're gonna look at what the right meant in 1780. And that's what I'm trying to see that if you agree that that's how we have to look at it, and if so, which I think is how we have to look at it, you know, what is the evidence that the framers, you know, viewed cake baking as protected speech 225 years ago?
Yes, Your Honor. If we look at the framers' intent of that, I would argue that the framers found that there is an inherent right to have speech, and I think the framers would recognize that speech was not decided to be one type of speech, whether it was a parade, as we've seen in cases presented by the council as well, whether that is choosing to exercise your right to contradict a conscription law. That has been, there's numerous examples, and the expression of speech has not been confined to one medium or to one type of speech. And the Constitution Amendment itself does not limit or constrain what type of speech is enumerated and
Well, we
protected.
talked about history, you mentioned free speech, what about the free exercise here? Scalia and the majority in Smith discussed the history extensively in our before some amendment opinion, except that, you know, the historical understanding at the time of the adoption of the First Amendment, which the states and their constitutions and laws and, you know, basically did not accept people because it's from general laws just because they had a religious section to. Right. So doesn't the history here support the correctness?
Smith recognizes, and we claim in there, that there was, the generally applicable statute there applied to these religious beliefs.
I guess my question is, whose history is right? Scalia's history and Smith or Alito's history?
Your Honor, I would argue that,
Or not, or, you know, we need some different historian.
we have the text of what the framers thought, and the text of what the framers thought is the First Amendment, and it does not constrain or limit the type of expression that should be protected or the type of exercise that should be protected. If we look to the Cantwell case in 1940, I know removed from the framers, but we've followed Cantwell since the 1940s. They recognize that constitutional questions there are highly sensitive, and that there should be a compelling interest in order to prohibit the exercise of religion, and that the freedom of speech should not be abridged. And we see the freedom of speech and the interest in exercising religion are both at play here in the Fines case. That's why I urge the court to return to.
I have one more question. I wanted to get your response to a question that Justice Agramonsky asked Mr. Preamble earlier. I'm not sure he realized it was intended to be a big fat softball. So Bruce Springsteen's song "Born in the USA" is played at the Trump rally. I think we will all agree that.
Don't stop thinking about tomorrow.
Yeah,
I think of an entirely different campaign.
Bruce Springsteen, that song is protected as his artistic expression, no doubt about it. But does anyone think that at the Trump rally, that by that song being played at the rally, that it is now Bruce Springsteen conveying any message whatsoever about the rally or the politician on whose behalf of the rally is being done?
Your Honor, I would argue that yes, that would be the case, just as the Fines.
Yes, people at the rally think, oh, Bruce Springsteen, they're playing Born to Run. Bruce Springsteen must be endorsing Trump.
The clients have the same concerns that Bruce Springsteen would have in that situation, or the fact that they're.
No, but you're missing the point. If nobody at the Trump rally thinks playing Born to Run is Bruce Springsteen conveying any message about the Trump rally, then why does anybody going to a wedding see a cake and think that it's conveying any message of the baker about the wedding?
Your Honor, I hope I'm not misinterpreting the question. I do believe though that an artistic expression present at an event, an extremely important event, whether that's a political event or a wedding, does speak something about the person who created that particular piece of art. Whether it is a song at a rally.
What is it, the difference between the creation and the use of the creation?
I'll ask it a different way. If I say to you right now, I'm the problem, it's me. Right? And is that, does anybody really think that like Taylor Swift is endorsing what I just said? Or am I just using lyrics that are today in the public domain to try to make my point? Right? Is it my speech or is T Swift somehow like coming through what I say to you with the bench?
Your Honor, here we do not have a simple slice of cake present at the wedding, just like you presented one simple lyric. It was an entire creation that was made in a very,
Okay,
complicated
so you hire
process.
Taylor Swift to sing at your wedding. Does anybody think that Taylor Swift is expressing any opinion whatsoever about the suitability of those two people to be married?
Since this court has held that speech should not be compelled, we understand that Taylor Swift would have the right to say no.
No, I know, we agree. I mean, we agree. You can't force Taylor Swift to play at anybody's wedding, but probably could force her if she agrees to play at white people's weddings, equally play at black people's weddings. The question, we're really talking about the second part of the Stone Johnson test now is, okay, if it's expressive art, then whose message is it? Do the people who see the cake at the wedding perceive it to be the baker's message?
Yes, Your
As I
Honor.
said, I don't think anyone at the Trump rally perceives Bruce Springsteen to be conveying anything about Trump when the song is played at the Trump rally. So why would people sing the cake at the wedding and think lines are trying to express anything whatsoever about whether these two people that they don't even know should be married?
Yes, Your Honor. In the highly particularized case of making a custom piece of something, a custom piece of art, we understand that there's a relationship there between the client and then the producer of the art. And it's obvious in the record that the clients take on work and consult with the client. And then when they produce that piece of work, as a result of that consultation with a combination of those interests expressed, they put a placard with their name at the cake and they advertise that they are the ones who made this cake. And it's the same thing as an artist signing saying, this is my work. And if it was commissioned, here's my work for you. So I would argue that the message is attributable to the person who created it and is participatory in the event that it's created for.
Thanks very much. Thank you, counsel.
Thank you, Your Honor.
The case is submitted.
Okay, if anybody's hungry, there will be a reception upstairs. I don't know if there's cake at the reception, but there will be. What about? Okay. Oh, we go to that. I gotta fill out my sheet. We go to the back. No, okay, okay.
Court stands in recess.
Well, we're